our teachers, and my dear fellow friends. Today, I, Disha Vimal, on behalf of D.F. Harish School of Law, would like to welcome each and everyone present here. Today, the Moot Society of PGCL will be giving us a demonstration on how a moot court is conducted. This moot problem is related to a criminal appeal. I am sure we are all eager to witness this stimulation. So I kindly request our guest to please begin the demonstration. Thank you.
Firstly, a very good afternoon to everybody present over here. Thank you so much, Fatima ma'am and college for hosting us. It's an honor for us to be over here. Today, our students will be performing a small demonstration on a moot court proposition. It is a criminal moot court proposition and it revolves around section 306 of the IPC, which deals with abatement of suicide, and section 482 of the CRPC, which deals with pursuit of the FIR. With this, we have a bailiff for the day, Ms. Anushka Mashramani. She will brief us with the rules of the competition and then we will begin. Thank you.
So hello everyone, I am the bailiff for today and I'll just brief you all with the rules of the competition. So each speaker will be taking 10 minutes. First speaker timing will be recorded by me and 2 minutes before the lapse of the time I will be ringing the bell. The courtroom officer will inform the judges and the teams who will be speaking next. The judges can ask questions anytime they want and there can be no cross-talking during the round. Any inconvenience observed by the judges or the participants can be conveyed to the courtroom officer. So the judges kindly note, Dhriti and Vatsala will be representing the appellant side and they will be taking 10 minutes each, and Dhriti will be going as speaker 1 and Vatsala will be going as speaker 2. And the respondent will be Devanshi and Amit, and Amit will be going as speaker 1 and Devanshi will be going as speaker 2. So Dhriti will be beginning with the round, I will just ask Devanshi to brief you about the facts of the case so you'll have a clear idea of what the case is.
Okay, so the case basically revolves around the main character whose name is Mr. Rajiv Mehta. He comes from a weak economic background and he's based in Gujarat actually. He came to Mumbai to study and make good businesses and everything. So in Mumbai, initially he worked with a shopkeeper who had a food stall, and Mr. Rajiv Mehta was known to have a sharp business mind. So he helped the shopkeeper, and the shopkeeper had gained his business largely. So later on, Rajiv Mehta finished his education and joined a small finance company which dealt with trading in shares. Now, he learned all the knowledge about trading in shares from that small finance company, and that's how he grew further. Later on, he found ways to make quick money. Now, his methods weren't exactly legal, how he found to make quick money. He started forging companies and started getting them listed in the stock market, and then they got floated. So there were no records of those companies, and that's how he earned quick money. Like, he took the money and the companies were shut down, so there were no records of the company. So this method was only known by his two close friends, that was Sumit Pandey and Abhishek Anand. Now, since they were close friends, they did not find it right to disclose it to anyone, and they kept going on with those methods. Later on, Rajiv Mehta, once he became a little successful, he dropped using these illegal methods and started carrying out his own business in a legal manner and started going on ahead. And soon he became the king of the share market. Now, meanwhile, his two friends, Sumit Pandey and Abhishek Anand, became bankrupt and were in a lot of debts. They came to their friend Rajiv Mehta to ask for help. So he not only helped them cover all their debts, but he also gave them jobs in his own subsidiary companies. Now, after a point, his friends started to become greedy because they knew that he is such a big personality and he obviously is doing very well in the business field. So they became greedy and they started threatening him, saying that they would go and expose him to SEBI and the police authorities. So they kept threatening him and he kept submitting to their demands in the fear of being exposed. So he kept giving them money whenever they asked for it. Now there came a point where they gave him an ultimatum. Now the date is to be noted, it was 15th of June that they gave him an ultimatum, and they told him that by 20th June, submit to our demands or we'll report you to the authority. Now Rajiv Mehta was in a lot of tension, and it is said that he also started suffering from depression. And on 18th of June, he was found in his bungalow, and he had committed suicide, leaving behind a suicide note where he also mentioned what all he had done, which is the illegal deeds and everything, as well as he mentioned how he was being threatened by his own two friends. So leaving behind all of these, the police arrested his two friends based on the suicide note and charged them with section 306 of the IPC, which is abetment of suicide, and later on it went to the Bombay High Court. Now, after some time, his two friends were released on bail, and the matter is again at present because the friends are seeking for quashing of the FIR. It is, however, to be noted that this investigation was still at the preliminary stage when they asked for quashing of an FIR. And there is also one small fact that I missed, that was Rajiv Mehta was also married in due course to Upasna, who is the daughter of a well-known businessman, and even her statements were taken where she claimed that in those 3 days, 15 to 18, Rajiv Mehta was very tense. He met with police officers frequently and also met with his chartered accountant. So these are roughly the entire detail of the fact sheet. Now the petitioners can go. Thank you.
I am the petitioner in this case for the defendant, and the council seeks permission to proceed with the arguments, to proceed with the statement of jurisdiction. The High Court of Bombay has the inherent jurisdiction to try, entertain, and dispose of the present petition by virtue of Article 226 of the Constitution of India, 1950, read with Section 482 of the Criminal Procedure Code. The council seeks permission to proceed with the statement of facts for the petitioner. Rajiv Mehta worked in the stock market with Abhishek and Sumit, both of his friends, who soon became friends. Thereafter, Rajiv made a lot of money, started his own business, and was soon proclaimed to be king of the stock market. And the three friends soon stopped meeting. On 18th June 2020, Rajiv was found dead. He had committed suicide, leaving behind a note alleging that his friends were extorting him for money. On the basis of this suicide note, the police filed an FIR under Section 306 of the IPC for abetment of suicide against both his friends. They were arrested and later released on bail by the High Court. Now, the friends Abhishek and Sumit have filed a petition under Section 482 of the CRTC to quash the aforementioned FIR. The council seeks permission to proceed with issue number 1. Whether the applicants have prima facie committed a crime under Section 306 of the IPC 1860. The council humbly submits that prima facie the facts and circumstances of the present case do not constitute a crime under Section 306 of the IPC. The council will begin the arguments by addressing the maintainability of this petition. This will be followed by a twofold argument, which will prove that first, the actions of the accused do not satisfy the ingredients of abetment as per Section 107 of the IPC, and second, that prima facie a crime under Section 306 of the IPC cannot be constituted on the basis of the FIR. Maintainability. So, adjusting the maintainability of this petition, the council humbly submits that the inherent powers under Section 482 are conferred with a very wide scope. While it is to be used sparingly, its primary purpose revolves around two objectives, which has also been laid down in the case of Madhu Limaye versus State of Maharashtra, which are to prevent the abuse of the process of court and to secure the ends of justice. The Supreme Court has laid down specific categories wherein the High Courts may exercise their inherent jurisdiction when a case is admitted under Article 226, read with Section 482. The court in the state of Haryana versus Bhajan Lal stated that the High Courts may use this power in cases where A. The allegations made out in the FIR, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute a crime.
Council, what is the Bhajan Lal case?
the Bhajanlal case was overruled, but the Bhajanlal case was overruled, but the place where the High Court stated the points of admission of a petition still hold good. B. The uncontroverted allegations in the FIR and evidence in support of the same do not disclose the commission of any offence. And C. Where the allegations made in the FIR are so absurd and inherently improbable that no prudent person can ever reach a just conclusion that there is sufficient ground to proceed against the accused. Therefore, the counsel shall prove that the allegations as made out in the unsubstantiated suicide note upon which the FIR has been filed are false, and that the actions of the accused do not prima facie constitute a crime under section 306 of the IPC, which will be reason enough for this honourable court to exercise its inherent powers and quash the FIR.
Counsel, what makes this case fit under the exemptions to quash the FIR?
In the subsequent arguments, the counsel will address your question, Your Lordship. A. The counsel submits that the actions of the accused do not satisfy the ingredients of abetment as per section 107 of the IPC. Your Ladyship, my arguments will answer your question. Section 107 of the IPC puts forth 3 ingredients, of which any one has to be satisfied in order to constitute a crime of abetment. These 3 ingredients are A. Instigating a person to do something. B. Engaging with one or more people in a conspiracy for the doing of a thing, which in turn results in an illegal act or an omission. And lastly, intentionally aiding another person by an act or illegal omission to do something. The counsel submits that the actions of the accused do not satisfy the first proviso of the section as alleged by the respondent. The crime of abetment, like others, requires 2 elements, actus reus and mens rea. In the present case, this would translate to a direct or any indirect act on the part of the accused, which has caused the deceased to take his life, and an element of intent to have wanted the deceased to take his life. In the case of
Can you overlook the fact that your client had changed the previous did blackmail the deceased? It is blackmailing the deceased to the point that he had to take his life. He kept on extorting his money from the deceased.
Your Ladyship, I agree with your contention, but blackmailing a client on the basis of a future action that a person might take because of your actions has been said in 2 cases. It will not constitute instigation of suicide. Even in the case of state of Gujarat versus Pratibha Jamarpal Mehta, the Gujarat High Court has stated that the reaction to a defamatory article cannot be predicted, and that it will not be attributable as an intention to instigate a person to commit suicide.
Was it a defamatory article? Because if your client would have, gone on and said that he was doing an illegal act, it wasn't defamatory. But if it is true, it cannot be defamatory.
Absolutely. So, give me 2 minutes while I read out my articles, your question will be addressed. So, in the case of Gurcharan Singh versus State of Punjab, a full bench of the Supreme Court held that merely on the allegation of harassment, a conviction under 306 is not possible. There has to be a positive action proximate to the cause of occurrence of suicide, which has then compelled the person to commit suicide. The threat posed by the accused on June 15, 2020 does not qualify as a positive action for the following reasons. Firstly, the accused did not take any real action against the deceased, merely threatened to do so. Second, they did so with an intent to extort money from him, not with the intention to cause him to take his own life. The counsel will also deal with the aspect of mens rea in the subsequent arguments. And thirdly,
Do you think that extorting money was the right action? That it is a justified action as well?
that will be dealt with by my co-counsel in her arguments in issue number 2. Thirdly, the accused could not have known that a man like Rajiv Mehta, who had faced many hardships early on in his life, was an intelligent man with many resources and connections, and he could take such an extreme step. The deceased in his suicide note alleged that he took the drastic step because he was afraid of his image being tarnished in the public eye. Now I will deal with the aspect of mens rea in the case, which is very important. Coming to the question of mens rea, the Supreme Court in many of its decisions has clearly established that it is very relevant aspect in the crime of abetment of suicide. In Vinod versus State of Maharashtra, the Honorable High Court held that it is necessary to at least prima establish that the accused had an intent to aid the deceased to commit suicide. It went on to say that in the absence of such material, the accused cannot be compelled for any action for the offence punishable under section 306 of the IPC. In the present matter, neither the facts nor the evidence presented by the police betray any intent on the part of the accused to aid the Rajiv Mehta to commit suicide. There is no reason why the accused would want Rajiv, who was their golden goose, a source of money for them, to take his own life. Even if we were to consider that the allegations made in the suicide note were true, it does not implicate them for an offence under section 306. Merely because the accused harassed and threatened them, it cannot be said that the deceased was pushed to take his life. Even in the case of Sriram versus State of UP, the court held that mere proof that the crime charged could not have been committed without the interposition of the alleged abettor is not enough compliance with the requirements of section 107. So, for example, if a person invites another person to an event and that may facilitate. Yes, yes. We'll give me 2 minutes, I will sum up my arguments. But unless the invitation was extended with the intention to have caused the murder, the person inviting cannot be said to have committed the crime of abetment. Therefore, there is no prima facie case for section 306. Primarily, the council would like to address that the aspect of prospective defamation as made out in the suicide note, even if the accused threatened that he would defame Rajiv Mehta and the council maintains it would be protected by the exceptions under criminal defamation, there is no cause to place the onus of the deceased's reaction to the accused. Therefore, the council humbly submits that in the present matter, a prima facie case of abetment to suicide cannot be made out against the accused. The aspect of mens rea, which is crucial in the offence of abetment of suicide, is conspicuously absent. The actions of the accused cannot be directly linked to the death of the deceased, and therefore the council concludes the arguments for issue number 1.
I just have one question.
Yes, allegation.
Has the charge sheet been filed?
No, indeed not allegation.
So can we not wait until the charge sheet has been filed and then can we not proceed with the report DFI, or should the investigation take place?
Yes, indeed for allegation, and this issue will be dealt with by my co-counsel in issue number 2. Thank you.
Council seeks permission to proceed with issue number 2. Much thanks. Issue number 2. Whether the FIR can be quashed under section 482 of the Criminal Procedure Code 1973. It is most humbly submitted that the FIR is filed by the police solely on the basis of the suicide note, and it results in an abuse in the process of law, which is why it must be quashed. To prove this submission, the council will look into 3 aspects. Firstly, the alleged act of extortion and lack of evidence to corroborate the same. Secondly, the credibility of the suicide note and mental stability of the declarant. And lastly, the absence of a prima facie case against the accused, and thereby concluding with the flow of the arguments that the High Court must exercise its inherent powers under section 482 and quash the FIR. Coming to our first contention, allegation of extortion. While it is submitted that the act of alleged extortion has no standing as it is based on the suicide note only, the council will first deal with the ingredients of extortion. Extortion is thus defined in section 383 of IPC as whoever intentionally puts any person in fear of any injury to that person or to any other person, and thereby dishonestly induces the person so put in fear to deliver any person or any property or valuable security or anything signed or sealed which may be converted into a valuable security commits the act of extortion. In the current instance, the first requisite of putting a person in fear of injury is not satisfied itself, as the applicants have not caused any fear of injury to the deceased.
Are you saying that the fear of the reputation, the state of the reputation of the deceased over here cannot be considered as a fear of injury?
Indeed,
then Pandey or your client would have said would be true, because at the end of the day, the deceased did gamble away the money, right? He did take place the illegal activities. So how are you trying to prove the point of defamation?
Indeed, that is exactly the point comes to like to put across, that there is no injury to the reputation because defamation is not taking place. Therefore, there is no fear of putting the person in injury. That's the first requisite of extortion itself is not implemented.
Actually, identity or the image of the person at the end of the day would get damaged. As much as the person has engaged into illegal activities, he was scared that once these illegal activities are known by everybody, the image will get damaged. So isn't that like an injury to the image of the deceased?
Indeed, Your Lordship. However, it is representing or bringing forward the truth of the matter, which itself is a legitimate crime which has been committed by Mr. Rajiv Mehta and that cannot be denied by each. Counsel seeks motion to proceed. Much offense. It is humbly submitted that there is no further evidence to corroborate this claim of extortion as alleged by the deceased in his suicide. The counsel submits that while the suicide note alleges that the applicants have extorted money from the deceased, there is clear lack of evidence to support that claim. For initial, the police have not recovered any bank records nor have they gained any information which suggests the same from the statements taken from Mr. Rajiv Mehta's A and Y, which can be seen as per, if I draw your attention, paragraph 10 of the Moot proposition. The FIR 2 in the current instance fails to mention the crime of extortion altogether, thereby precluding from the present matter.
Coming to the following, the investigation is still going on. You want to watch the FIR before the charge sheet is filed, before the investigation is completed. How can she find something?
Your Ladyship, I request permission to proceed with further arguments as it will answer the question. Coming to the second contention, the credibility of the suicide note. It is humbly submitted that a suicide note is not as credible as a dying declaration. A dying declaration, as explained in section 32 of the Indian Evidence Act 1872, is a written or verbal statement made by a person stating the cause of his death or the circumstances that led to it when the person's death is in question. It is based on the Latin maxim, never mortis spes salutare mentat, meaning that a man will not meet a maker with a lie on his lips. While a suicide note satisfies the criteria for a dying declaration, it is not as substantial as the circumstances of the cases differ widely. The statement recorded as a dying declaration in a homicide case is recorded in the presence of either a magistrate, police officer, doctor, or any such authority, while a suicide note is made only in the presence of the declarant. Therefore, it is not possible to counter-question it to check the veracity of the averments made in the submission after his death. Because there is no accountability or ownership, the authenticity remains doubtful. Evidence submitted in a court of justice is given on oath, and any witness that violates the sanctity of the oath by narrating facts that are untrue to his knowledge exposes himself to be punished for perjury under section 191 of IPC. Furthermore, testimony of a witness in a court is liable to be scrutinized and tested by cross-examination. But a dying declaration is not subject to any of the above safeguards to guarantee its truth. In fact, in the case of Lakshman of the state of Maharashtra, it was held that a situation in which a man is on his deathbed is so solemn and severe that the reason law accepts the veracity of the statement and eliminates the need for oath and cross-examination is because of this. However, in a case of suicide or leadership, there exists no impending death on the declarant of the suicide. Therefore, this criteria is not satisfied. The statement must not be relied upon. Coming to the mental stability of the declarant, it is submitted that the deceased is a hypersensitive individual, as within 3 days from receiving a deadline, he went into depression, as if from mere common cold, but in fact it is an actual disease which cannot stem overnight. So, for this, I would like to take reference to paragraph 8 of the Moot proposition.
Counsel, I would just like you to try to defend the acts of your own clients, because do you think that then blackmailing the deceased was also a right thing in the first place?
Indeed, Your Ladyship. While Mr. Rajiv Mehta having made his fortune through illegal methods, he knew all the while that he could be subjected to full force of law and for committing crimes along his way. But this burden did not seem as heavy to Mr. Rajiv Mehta because it was substantially mitigated by the profits he had made along his way. So while it is the allegation of extortion that is claimed by Mr. Rajiv Mehta in his suicide note that the applicants have extorted money from him, there is no proof to corroborate that they had indeed extorted money from him. So the counsel is trying to
There's no charge sheet filed, no investigation has been completed. So for us to assume that there were no bank records, isn't it too early to say that to make that assumption?
need your leadership. However, I would like to bring your notice, as can be seen on paragraph 8 and 9, that this incident has occurred in 2020. And it has been 2 years that the police have simply been investigating and pulled out, and they still have no evidence to corroborate the Mr. Rajiv Mehta has gone to his CA, he has gone to the police himself. If indeed there was extortion committed, I would like to draw your reference to paragraph number 10. With the permission of the court, I would like to read the paragraph out. Much obliged. During the investigation, the police took Upasana's statement whereby she disclosed that Rajiv, though looked happy and calm, there was something wrong as he met various police officers between 15 June 2020 to 18 June 2020. It was also informed by Upasana that Rajiv met his chartered accountant in the last 2 days. Your leadership, if indeed there was an act of extortion, Mr. Rajiv Mehta had ample opportunity to take help of the police and punish the applicants for the crime of extortion if they need any extortion had taken place. But he has not.
Can you please read out paragraph 6 of the proposition?
Any condition. On gaining knowledge of the turnovers and profits of Rajiv, Sumit and Abhishek enjoyed envious rise of success. Since Sumit and Abhishek knew the manner in which Rajiv initially accumulated the money for business, they decided to blackmail by revealing his secrets. In your issue, there is no proof of the fact that there is no evidence to corroborate the suicide note where it says that he was extorted for money. And it can only say that simply on the basis of the extortion of money he has taken his life. As it can also be seen in paragraph 9, that he was being guilty of the fact that he had made money through illegal means. And that also amounted to a huge part of the reason why he committed suicide and took his own life. If the counsel of the nation was satisfied, counsel which is the same.
Oh, that's fine. Shut it up. Okay, I'll give you the next 2 minutes.
Indeed. Much less. Counsel come to the last contention, that is the power of the High Court under Section 482 to quash the FIR. It is most humbly submitted that the inherent powers of the High Court are to be exercised to prevent the abuse of process of any court or to secure the ends of justice. The Supreme Court, in Barakat by Kandis versus State of Gujarat, after observing several precedents on the subject, laid out certain broad principles in the exercise of this inherent power. The power to quash under Section 482 is attracted even if the offence is not accountable. Second, in forming an opinion whether a criminal proceeding or complaint should be quashed and exercise its jurisdiction under Section 482, the High Court must evaluate whether the ends of justice will justify the exercise of the inherent power. It was held further in Madhav Rao vs. Sambhaji Rao that if the court is of the opinion that the chances of conviction are bleak, the court, while considering the special facts of the case, may choose to quash the proceedings even if the allegations are made at a preliminary stage. Therefore, I lodge to reiterate, in the present matter, the FIR has been filed solely on the basis of the allegations made out in the contents of the suicide, with no corroborating evidence to support the claim. An investigation has a certain procedure to be followed, and the first 2 steps of an investigation in this procedure are to collect evidence and taking witnesses, both of which have been done. I request me such a 1-minute sum of the outcomes. Much thanks. The first 2 steps in a procedure for conducting an investigation is collection of evidence and taking witness statements. As can be seen in paragraph 10 of the fact sheet, both these stages have been completed since the police has taken witness statements from his wife and his CA. And therefore, despite conducting these 2 steps, there has been no conclusive evidence found which backs the allegations made in the suicide note against the accused. It is also important to note that this investigation began in 2020 or less, and the applicants have been subjected to this misery of this long drawn-out trial for this investigation for way too long duration, and therefore it is the earnest request that the High Court must exercise inherent power under Section 482 and quash out the FIR. Coming to the Shaman seeks permission to proceed with the prayer. Much next. In light of issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this Honorable High Court that it may be pleased to adjudge and declare that the FIR in the present case be quashed and pass any such order, writ, decree, or judgment that this Honorable Court may deem fit in light of justice, equity, and good conscience, to which act of kindness the applicant shall never to be bound humbly fail. Much obliged.
The lead is the council seeks permission to address the matter. Your leadership, the council seeks permission to proceed with the issues that your leaderships are well versed with the facts of the case. Your leaderships, in the present matter, I will be dealing with issue number 1, which being whether there has been a crime committed under section 306 of the IPC 1860. Now, leadership, I will be dealing with this contention in a 3-fold manner. Firstly, I will be dealing with the aspect whether the petition itself is maintainable under Section 482 of the CRPC. Secondly, that the actions of the accused satisfy the ingredients of Section 107, which constitutes an abatement. And thirdly, your aim whether there is a proximate nexus between the acts that have been committed by the accused and the suicide committed by the deceased. Now, dealing with the first contention, whether the petition is maintainable or not, as my learned petitioner rightly pointed out, the inherent power under Section 482 is to be used sparingly and in the rarest of the rare cases. My learned friend had also cited a case law for the same. I will take an opportunity to cite another case where the matter of state of Orissa versus Somar Sapo, in similar lines to the Moot case which my petitioner cited. The court had also laid down three conditions where this inherent jurisdiction needs to be invoked. First being to give an order under the CRPC, and the second, which are concurrent to what Madhur Limai case held, to prevent the abuse of process of law and to secure the ends of justice. Now, ladies, the power to quash under this provision is not to be applied as a rule but rather as an exception and to be used only when it is evident that the advancement of the case to a trial stage would do a grave injustice to the accused. So, ladies, to be honest, we are still at the preliminary stage of investigation. We are not yet fully corroborated all the evidences at hand, and it would be really premature of us to quash this trial or quash this FIR in the first place. Your Ladyship, we need to take into consideration that this petition is for quashing of an FIR and not a bail application. If once this petition is quashed itself, there remains no further opportunity for the victim and the family of the deceased to go for any other redressal. So, Ladyship, these two things need to be taken into consideration before even going into the maintainability aspect. First, the investigation is at a very preliminary stage, and secondly, out of all the circumstantial evidences that exist, there seems to be a prima facie case that there has been an offence under Section 306, which the council will be further arguing on. Moving on to my next submission, that whether the actions of the accused satisfy the ingredients under Section 107, which talks about abatement. Your Ladyship, if you may peruse to the bare verbatim of Section 106, you may get to know that Section 106 requires three special ingredients for an abatement to be taken place. Firstly, there either has to be an instigation by the person to do something, or there should be engagement with one or more people in a conspiracy of doing a thing, or thirdly, intentionally aiding another person by an act, illegal omission, or to do something. Now, ladies, in the present matter, we need to focus on the very first part, that is instigating someone to do something. This crime, like all the other crimes, does require an aspect of mens rea and actus rea, which in the present matter translate to direct or indirect act by the accused, which led to the commission of suicide and the intent to cause that suicide. I would lay Relevance.
Sir, I have one question. If the accused wanted the deceased, like if their motive was that that the deceased commits suicide, don't you think that they were gaining money out of it? Why would they want that? If the deceased, if Mr. Rajiv Mehta, if they wanted Mr. Rajiv Mehta to be there, won't their sort of income also be stopped from? Why would they want that? They were gaining from it. They were gaining money from it. So if Mr. Rajiv Mehta is moved, their income is also stopped. So why would the accused want that?
Your Ladyship, much obliged for your question. Your Ladyship, firstly, it is their ulterior motive which the council itself is not aware of. However, the peculiarity of this section is that your Lordship is focused on the decision in the matter of Uday Singh or the state of Haryana. But the court held that the question of mens rea on the part of accused could be examined with reference to the actual acts and deeds of the accused and not with respect to what's going on in his mind. In the verbatim of the court, it has said that if the accused plays an active role in tarnishing the self-esteem and self-respect of the victim, which eventually draws the victim to commit suicide, the accused may be held guilty of abetment to suicide. The question of mens rea on the part of the accused in such cases would be examined with reference to the actual deeds and deeds of the accused, and if the deeds and acts are only of such whether the accused intended nothing more than harassment or snap show of anger, a particular case may fall short of offence. However, ladies, please listen to this. If the accused kept on irritating or annoying the deceased by words or deeds until the deceased reacted or provoked, a particular case may be fit for abetment to suicide. If we look on paragraph number 7 and 8 of the Moot proposition, we can find instances where there have been extortion committed by the accused. There has been a suicide note in the present matter which has impleaded the accused in the present matter and the deeds that we have done. Talking about the fact,
Why aren't the accused charged with extortion?
your leadership, as of now, preliminary stage, the FIR has been filed. The only information that we have been received that the deceased has committed suicide, and we have only taken the cognizance of the suicide note, and accordingly we have decided to
Are
charge
you
him.
arguing on the validity of the suicide note or the contents of the suicide note?
Indeed, your leadership, as my learned petitioners have also pointed out, the validity of contentions, the validity of the suicide note itself. We can find relevance of the suicide note under section 32 of the Indian Evidence Act. Your leadership, without wasting much of the court's time, even if we take for the sake of arguments that a suicide note is not equivalent to a dying declaration, the court in the matter of Harpal Singh Durgabai versus State of Gujarat in the year 2014, which is much recent, and held that even if the suicide note does not constitute a dying declaration under section 32 of the Evidence Act, it is still relevant as per section 6, 11 and 14 of the Indian Evidence Act. With your leadership's permission, if I may just iterate what the sections say. Your leadership section 6 reads relevancy of facts forming part of the same transaction. Over here, the term transaction needs to be construed in the sense the entire act since they got in touch with the person to the time when the suicide has been committed. Section 11 reads as when facts not otherwise relevant become relevant otherwise. Your leadership, we do not have anything other than the suicide note to give emphasis on whatever has happened. So that is the only evidence and that is the sole basis for which we need time to investigate. And all of them, if we corroborate them together, it's not like it's just the suicide note or the extortion we are talking about that has led to the suicide. It is the collective effort, the collective things that the accused has done that has led to the same. I would also be iterating a case law wherein the Supreme Court had said, just give me a moment, your leadership. Yeah, as I had iterated earlier, Mencia does not require the actual intent of the person, the acts and deeds are sufficient enough. So I would move on to my next argument, which is the proximate nexus between acts of the accused and suicide committed by the deceased, wherein I will be answering this question. When you see the verbatim of section 306, we can see there are two essential ingredients. One being the amendment itself, which I read earlier. Second being the intention of the accused to aid, instigate, or abet the deceased to commit suicide. Now, going ahead with the observation that has been made in the matter of Uday Singh, the accused threatened the deceased knowing that he couldn't fulfill that demand after a certain point, and that the idea of exposure and the subsequent harm to the reputation and his business was not acceptable to the deceased. The ultimatum that was proposed to the deceased left the deceased with no choice but to take his own life. It created a set of circumstances which frustrated the deceased and left him with no other alternative but to take his own life. This contention is supported in the matter of Pawan Kumar that if the accused by a continuous course of conduct creates a circumstance that a person is left with no other option but to commit suicide, instigation may be referred. Thus, it is your leadership does
Counsel, I have one last question. Don't you think there is an abuse in the process of the court as the deceased committed suicide due to his own fear of his crimes being exposed, not because of extortion? At the end of the day, the deceased did commit, and he committed suicide because he was scared that his reputation will be damaged. So, don't you think it is an abuse of the process of the court?
much obliged your leadership. Your leadership firstly to deal with this question. It is not brought to the. It is not proven to be a fact that accusers commits. The deceased has committed so and so stuff. So he is innocent until proven guilty by our English jurisprudence. Secondly, your leadership, if that is the case, then petitioners themselves has come to the court with not clean hands, since they have committed an act of extortion. Your leadership. Much obliged your leadership. Yes, your leadership in the matter of Praveen Pradhan was the state of Uttarakhand. Your leadership, the councils are various exhaustion. Just give me 2 minutes to summarize that. Much obliged. The Honorable Supreme Court had said that it isn't necessary for the investigation to be specifically suggestive of the consequence. Just a reasonable certainty to incite the consequence must be spelled out. In the present matter, the suicide note has identified the whoever the accused are, the ultimatum has just added that spark to the life of Rajiv Mehta to take this drastic step. As alleged by the petitioner that he was in touch with the police officers, he was in touch with the chartered accountant. Your ladyship, the situation was so dire from him in that situation that he was left with no other option. And if petitioners are contending that there is not enough evidence and investigation has been taken like 2 years, your ladyship, we all were aware of the situation of our country back in the year 2020 when COVID pandemic had come. So your ladyship, we ourselves were burdened with too many tasks at hand. Crime rate was increasing. So, leadership, if you are pleased, then please expedite this proceeding, and we would be more than happy to cooperate with the court. Your leadership, but this is a petition for quashing of an FIR. This is not a mere petition for bail. And if it is for the means of justice, we are very well ready to cooperate with the court if investigations are to be expedited. But that is no proper and solid ground to quash the FIR in the present matter, your leadership. With this, your leadership, I humbly conclude my argument, simply stating that there seems to be prima facie is at the face value of it, that there seems to be an offence committed under section 306, and all we require is time for the investigation to complete, since it is at a very preliminary stage, and all the dots to be connected in the present matter, your leadership. And hence, the council humbly the rest of this case.
The leadership option to close the file. The leadership council will be dealing with issue number 2, which says that whether the High Court can or cannot grant the quashing of an FIR under section 482 of the CIP. It is humbly submitted that the petitioners have been charged presently under section 306 of the IPC, and with the completion of the investigation, it is submitted that the FIR should not be quashed under section 482 of the CIP. Now, section 482 of the CRPC is read as nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. Your ladyship is forming an opinion that a criminal proceeding or complaint should be quashed in exercise of its jurisdiction under section 482 of the CRPC. The High Court must evaluate whether the ends of justice would justify the exercise of this inherent power. And it is to be noted that this power should be exercised with caution and should be done in the rarest of the rare cases. The decisions of the High Court in this regard ought to be guided by the following twin objectives laid down in the case of Narendra Singh versus State of Punjab, where it was stated. The first objective was to prevent the abuse of the process of the court, and second was to secure the ends of justice. Now, your ladyship, in the present matter, it does not fall under the rarest of the rare cases, since the investigation is just at the preliminary stage of the present matter, and it should not, and quashing of the FIR at such a stage would not secure meeting the ends of justice. And in a following other case, the Municipal Corporation of Delhi versus R.K. Rudaki case, it is reiterated that it is therefore manifestly clear that the proceedings against an accused in the initial stages can be quashed only if on the face of the complaint or the papers accompanying the same, no offence has been constituted. In other words, the test is that the allegations and the complaint as they are without adding or subtracting anything. If no offence is made out, then the High Court will be justified in quashing the proceedings in exercise of its powers under section 482 of the Code. Now, in the present case, the police has clearly charged the petitioners under section 306 of the IPC, based on the basis of other circumstances as well as the suicide note, which was stated in the facts, and the suicide note does include how even Mr. Rajiv Mehta did commit those deeds as well as how he was constantly being threatened by the petitioners. So, mentioning the petitioner's names and everything in the suicide note is what led to the police to charge them under section 306 on the basis of the suicide note. And it should also be understood that the powers under section 482 of the CRPC are to be used in order to make sure that the process of law is not in any way abused or misused. Coming to the landmark case of State of Haryana versus Haryana, the Supreme Court stated that the powers under section 482 of the CRPC should be exercised only when the allegations made in the FIR, even if taken at the face value and accepted in its entirety, do not prima facie constitute any offence or make out a case against the accused, or where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence or make out a case against the accused, or the allegations made in the FIR or complaint are so absurd and on the basis of which no prudent person can ever reach a conclusion that there is sufficient ground for proceeding against the accused. And the High Court, being the highest court of the state, normally refrain from giving prima facie decision in a case where the entire facts are incomplete and hazy, more so when the evidence has not been collected and produced before the court, and the issues involved, whether factual or legal, are of magnitude and cannot be seen in its true perspective without sufficient material.
Has the suicide note been verified and authenticated? Has the suicide note been verified?
The petitioners have been presently charged on the basis of the suicide note, and there has been just a preliminary investigation conducted. So it is not complete as such, which is why the facts are incomplete at the present matter.
So can we actually examine the suicide note as a deciding factor to proceed against the investigation?
That would be done in the further investigation and not at the preliminary stage.
That's what I'm saying. Can we continue with the investigation on the mere basis of a suicide note, of which we do not have any verification or authenticity, because the case has been already going on for the past 2 years?
Immediate however, the point at here is not just the suicide note, because the fact sheet also states that the petitioners had a view to extort money, which clearly also submits that there were other circumstances involving this present matter and not just the suicide note and the crime of the fact that Mr. Rajiv Mehta has committed suicide. There was also other factors where he was being threatened, which led him to take such a step. And had he just wanted to save his image, he wouldn't have even mentioned the fact that he committed those illegal.
He was threatened about his image only.
He was threatened about the deeds that he had committed previously.
Are you saying that the deeds were justified?
In
Him
his
extorting, as much as the accused over here have, so-called extorted money from Rajiv Mehta, don't you think Rajiv Mehta has done the same from the female out there, while he illegally gained money through the share market? Isn't that extorting money from the common man?
Indeed, not your ladyship, since in the pure definition of extortion under section 383, it was said that it is also to create fear and to threaten. Rajiv Mehta, although had taken money, he did not create any kind of fear in those companies or to the stock market, neither did he threaten them with in the share market. So clearly at this stage, since it's a preliminary investigation, more investigation needs to be dealt with, and then the court may decide what is fair and what is just as per the court. And in the present case, by quashing the FIR, the High Court will not propound justice to preserve its inherent power, that is, as it is evident that prima facie that the petitioners have instigated Mr. Mehta to commit suicide, which can be inferred from the facts, circumstances, and the suicide note on record, which clearly substantiates the illegal nature of the acts by the petitioners. Moreover, there is no settlement made between either of the parties, and thus the High Court doesn't have a valid reason as per the principle to quash the case. And normally, the quashing of a criminal proceeding or FIR is often observed in matrimonial and civil disputes, where the matter is more of a private one and does not affect the public at large. But the crime committed by the petitioners in the pursuant case is a grave and serious offence. The illegal demands and acts of the petitioners led the victim suffering from depression and committed suicide, which makes it an issue of public concern, because Mr. Mehta was no ordinary individual and his suicidal death will affect the societal mindset and raise questions whether justice has been meted out actually or not. Mr. Mehta was a public figure since he was clearly referred to as the king of the share market as stated in the facts. Hence, his death is not just an ordinary one and would affect the public at large as well. And in the present case, there is a prima facie case constituted against the petitioners, and being at the preliminary stage of the investigation, the counsel pleads the court to allow the investigation to be dealt with further, and the matter should be looked upon. As it is humbly submitted before this honorable court that taking into cognizance the establishment of a prima facie case against the petitioners, the FIR should not be quashed to uphold the principles of justice and fairness.
Answer 306 is not made out, but extortion seems to be the case. So is it okay if the FIR is quashed and then you can proceed or initiate the proceedings of extortion?
In the not your ladyship, the FIR should not be quashed, since rightly said by my co-counsel before that this particular case is not for a bail application. The petitioners are at present on bail, and they are not. They are seeking for quashing of an FIR where the matter has not even been dealt out further. The investigation should be complete. The charge sheet is left to be filed. At this stage, let the matter be, the council seeks permission for the matter should be dealt with properly and the investigation should be carried forward. If your ladyship is satisfied, the council seeks permission to move forward to the prayer. Therefore, in the light of issues raised, arguments advanced and authorities cited as most humbly and respectfully requested that this honourable court adjudge and declare dismiss the petition filed by the petitioners, the denying of quashing of the FIR against the petitioners, and issue orders to resume the investigation and probe into the matter at hand, and pass any other order, decree, or judgment this honourable court may deem fit in the light of justice, equity, and good conscience.
Much less. Coming to the first aspect of the sections mentioned by my co-counsel, sections 11, 11 of the Indian Evidence Act Ladyship, the evidence that is submitted of the suicide note is not being denied, and those sections simply refer to the appreciation of evidence and not regarding the contents of the suicide note. The Ladyship coming forward to the next point that this under section 174 of the CRPC, an investigation must be completed within 6 months and a charge sheet must be filed. For Ladyship, in the current case, this case has been going on since the year 2020, and while COVID, the pandemic has taken place, it's not an excuse to prolong the process for 2 years, and it should be simply shows incompetence on behalf of the police and the authorities, and which is subjecting the applicants to undue pressure and stress by this prolonged trial duration. The issue lastly comes to the fact that the suicide, as mentioned by the co-counsel, that the suicide note that Mr. Rajiv Mehta's crimes were not proved and he is innocent and proven guilty. It is unfair. It is unfair to assume that certain facts of the suicide note are relevant and by completely disregarding the others. That's for the convenience of my opposing counsel. Much better relation. Thank you.
Your litigation firstly dealing with the first part, they said that contents of the suicide note are not denied by the litigation. I think the council is more than obliged that they have accepted this fact that the contents are not denied, and it should be further used to corroborate the situations. Secondly, they said that as per the provision of CRPC, investigation needs to be completed within 6 months. The litigation indeed we agree with it. But this situation has come after a century where the entire country has gone under a lockdown, which asks for an exceptional attention. It's not the fact that they are in jail, your ladyship. Had they been in jail and we had rejected the bail application, it would be a matter of their fundamental right. But your ladyship, that is not the case. It is quashing of an FIR that they have come before this honorable court. And your ladyship talking about the fact that they have alleged that we have, as per our convenience, excluded the part of the suicide note and not the part. Your ladyship, it is something the council said only for the sake of argument. Whatever happened is something for the law to decide, and the accused are not in a position to decide what the deceased has done. Your ladyship, the council consultants. That's all.
You guys want to say something? Just say thank you for having us over here. We also expect a lot of tips and tricks and something from you guys. Please wait. We have some. Can you please come over here? I hope you guys enjoyed that. Yes. Yeah. I hope it was informative. Yes.
You guys saw what we performed was basically a moot round. That's how a moot court round happens. But I'll break it down for you so you understand better how you are supposed to perform it. Maybe you missed it, maybe you went too fast. So firstly, for any instance, you always take the permission of the court. Okay, the court is like obviously the highest authority. You have to show a lot of respect to the court. So before, like even when Nitisha or when the judges are asking questions, let them ask how much ever. Never interrupt the judge when the judge is talking. Say yes, yes. So it's very formal way in a moot court, which doesn't normally happen in an actual court, which is changing, but it's not. But you always address yourself in like third person. It sounds very Shakespearean, but you call yourself counsel. You don't call yourself may I proceed, may the counsel proceed. So that way, today we were lucky that we had two lady judges, but sometimes it's one girl, one boy. So you ask. Council seeks permission to address the bench collectively as your lordships or ladyships, whatever you prefer with going. And before you start, you always say, okay, your ladyships, I am counsel for the petitioner and your team court, and I will be speaking on these issues. My co-counsel will be addressing these issues. So you lay out everything clearly before the bench, before you start. Okay? Then you move on to your arguments. Again, before you start anything new, counsel seeks permission to proceed with the statement of jurisdiction. Counsel seeks permission to proceed with the statement of facts. Statement of jurisdiction is just addressing how you come into the court. In the current case, it was section 482 of CRPC, and that's how you mentioned. So section 482 read with section 226, which is the inherent powers of the High Court, writ jurisdiction, etc. And then you proceed with the statement of facts. So while a fact sheet it's like your Bible, you always adhere to the fact sheet for everything. So if you ever are getting confused, you have to remember that you will know the fact sheet better, like the judge will know the law better than you because they are practicing, they know more about it. But you will always know the fact sheet better than them because they would have gotten their like fact sheet or arguments 2 days before. But you have been prepping for it for more than 2-3 months. So whenever you're in any doubt, you come back to the fact sheet and you raise like but factually what I'm saying makes sense. That's how you go about it. So when you say statement of facts, so like Dhriti mentioned statement of facts, you don't necessarily depict the facts the entire way that it is mentioned in the moot proposition. You can twist it to suit your side. So for petitioner's side, we did not mention the fact that while stating the statement of facts, that there was extortion committed. We said they were friends, then he died. That's it. We don't want to bring up that, our client has done something wrong. So you try to keep it as clean as possible and as short as possible because nobody is going to listen to you go on and nobody has time for it. Usually when the rounds are going on later, the judge will ask you to skip the statement of facts altogether because they don't have time to take everything up and they just want to wrap up the matter. Okay. So after statement of facts, you start with your arguments. So when you are researching for your arguments, there's a standard format. It's very good if you mention that these are the points I'm going to be raising because if you initially start raising your points, the judge doesn't know what your flow is. So if you mention I'm going to be addressing the maintainability, I'm going to be addressing the suicide note, then I'm going to be addressing the powers of the High Court. That's how the High Court has the power and that's why it should be quashed. So you're mentioning whatever you're going to mention in like 2-3 lines. So the High Court, the bench knows what you're talking about, so it's easier for them to understand the contentions that you're making while you're making them. So yeah, when you make your contentions, first you speak about the issue. Okay, the contents of the suicide note. Then you talk about the reasoning, why the suicide note is not relevant. Because it's the only evidence, because only the declarant was there when he wrote the suicide note. He wasn't dying, he could have died whenever. So that's how you explain the reasoning behind why you raised that issue. Then you talk about the analysis, or you use the ratio. So that's how you research. That comes part of your research when you use Manupatra or SEC or any legal research platform. You will find case laws which will be similar. But when you're looking for case laws, try looking for case laws which have similar facts to those that is relevant to your moot proposition. You will not always get case laws which are relevant, but don't ignore the entire case law itself. Like if one part is completely opposing it, you should always be aware of the case laws you are citing. Today we cited, like I cited some 7 case laws, Dhriti cited some 5 case laws, everyone cited. So today we were fortunate enough that the judges did not ask us the facts of our cases. But Nitisha did mention in the start, but wasn't the Bhajandar case overturned? But we should know that okay, this case has been overturned, but even if it's overturned, what they held over there is not like get invalidated. It was because of the factual discrepancy that the case got overturned. So you should be aware of the cases that you are citing as well, and you should know them well. So that the judge asks you, you're not stumped, you shouldn't be lost for words. Moving forward, the last way you connect the law, the facts, and the case law. So you have to give a brief about the case law. In this case law, the victim was very sensitive. In our current Moot proposition, the victim is so sensitive. That's how that case law applies over here. That's how this law applies over here, and that's why we are contending that you should not hold. That's the broad way in which you frame your arguments. And in the end, you always conclude with, you go back. Like the issue is whether the FIR can be quashed under section 482. Your end is always, therefore, concluding by the flow of the arguments, the FIR must be quashed. Your starting of the issue when you begin is always the answer to the issue, and your ending to the ending of your arguments is again the answer to the issue. You repeat it twice. So the court knows this is what you are asking for, FIR to be quashed. And then you move on to the prayers. Once again, the prayers, it has a format. In light of the issues raised, arguments advanced and authorities cited, it's kind of like it's just a format, you just have to say it, there's no reason for it, you just have to be polite and make sure you follow the format. And you list down what prayers, meaning what you want the court to do right now. So we just wanted the court to quash the FIR. We could have also asked for damages, but we were considerate because, the guy died. So we're like, no, we won't ask for damages, he's already dead, that's enough. But we don't want to be subjected to this torture, so we want the FIR to be quashed. And again, there's a little after that also, in light of justice, equity, and good conscience. It's just formalities and you're being very polite to the court, because that you have to maintain at all times. No matter how much the judge is pressurizing you or pestering you with questions, you always answer, I agree with you, however. Indeed, your ladyship, however. You never outrightly disrespect, because if you disrespect, then you're gone. No one is going to listen to you. The judge doesn't want to listen to you after that. So it's a lot based on obviously your arguments, but it also depends on the way you handle your judge, because all judges are not as nice as the bench we had today. But you will be getting bad judges, and you just have to find a way to deal with them and be really polite with them. And also, when a judge asks you a question and you don't know what the answer to that is, you just don't know. Don't make up things. Don't faff your way through. You do not lie to a judge, because the judge knows the law. If the judge asks you, wasn't this overturned, and you are not sure of the fact, then you can ask, you take permission, your ladyship, I would like to come back to that question. Or your ladyship, my co-counsel will be dealing with that question. So you will pass it on to the next person, or while, like say, Thriti is speaking, I know she doesn't know that, I will try to look at today. We didn't carry books, but you can carry your constitution, CRPC, you can carry your matter with you, and you can actually check if it holds true, if it doesn't, and then you come to know. But that's about it I have to say today. I think I spoke a lot. But if you have anything, yeah. Thank you.
I now request our director ma'am, Dr. Nilima Chandaramani, to please come out and give the participants their medals. Rushi, could you please ask?
Teachers can come forward. Come.
afternoon, everyone. It has been an honor to be a part of this wonderful event. On behalf of DM Hari School of Law, I would like to extend my heartfelt gratitude to our director, Dr. Nilima Chandaramani ma'am, and the principal of SVKM, Praveen Gandhi College of Law, Dr. Navshika Duara ma'am, for sending the best team for Moot Court from their PGCL's Moot Court Society and the members of our Moot Court committee. A sincere thank you to our professor, Ms. Ridhima Singh. Finally, I would like to thank all of you present here for making the time to be with us today and helping us make this event a grand success.
I request everyone to kindly rise to the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जल वितरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाए तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you all very much.
Thank you.
Thank you.